Good afternoon, everybody, and welcome to this afternoon's short webinar arising out of the case of Mazur and Charles Russell Speechlys that was handed down 2 weeks ago tomorrow. I'm delighted to welcome you on behalf of King's Chambers. I have with me today Fraser, Barnstaple, who is also a member of our costs and litigation team here at King's Chambers. We're going to run you through some of the key areas of the judgment, the background facts of the case itself, the key relevant provisions of the Legal Services Act 2007 that were being examined by the court in Mazur, the decision of the judge, Mr. Justice Sheldon, and the reasoning underpinning that decision, and then move on to look at what is the conduct of litigation for the purposes of the Act, the restricted activity, and what might be done to, in a practical sense, minimise risk to your practices. Now, I have to start today, first of all, with a thank you for all of the interest that's been garnered for this talk. We've had over 1,300 people subscribe to the webinar, which I believe is a bit of a record. Next time we might have to do it at the Opera House or something if we hit these sorts of numbers again. But one thing I do want to say is a little bit of a health warning at the beginning. This is a brief webinar. It's only 45 minutes long. There's been a huge amount of interest in this decision since it was handed down, and we've seen a large number of articles online already which comment on this decision to varying degrees of accuracy in our humble opinion or opinions. The aim of this webinar, in a nutshell, is to assist those who might be impacted by the judgment and help them understand the ratio decidendi underpinning the judgment and some of the implications which may follow from it. What's important for me to emphasize at the outset is that nothing we say this afternoon should be taken as legal advice of any sort for your own practices. The range of possible ramifications from this authority are considerable. I think everybody here will recognize that. And at least some of the authorities that we'll look at today demonstrate that the application of the law in this area is likely to be extremely fact-specific, and how firms are organised, how individual practices are run are likely to be the determining factors. Anybody who thinks that they might be affected by this decision shouldn't rely on any comments that we make this afternoon, but should obtain their own formal advice in respect of their own individual firms or practices. So, with that said, I'll now pass over to Fraser. He'll talk us through the background of the decision and how Mr. Justice Sheldon came to the conclusions that he did.
Thank you very much for that, Kevin. Jumping right into the background facts of Mazur, and starting from the beginning, so to speak. The respondent, who I'll refer to as CRS, carried out some legal work for Mrs. Mazur. Now, it was alleged by CRS that just over £50,000 worth of fees were owed by Mrs. Mazur to CRS. Consequently, CRS instructed GBS to recover the debt. And that's when perhaps the main character comes in, Mr. Middleton. Now, Mr. Middleton was the head of commercial litigation at GBS, the firm handling this debt recovery claim. And he undertook many, if not all, of the salient steps in that litigation. And actually, all of those steps are listed at paragraph 8 of the judgment in Mazur. And I counted, very sad of me, I know, but no fewer than 28 individual steps were carried out by Mr. Middleton, who was, of course, unqualified. Importantly, we had Mr. Middleton signing the claim form and particulars of claim, and then filing and serving them on the defendant/appellant, Mrs. Mazur. Now, Mrs. Mazur took issue with Mr. Middleton's involvement, or at least her legal team did, and made an application for Mr. Middleton to be replaced with a qualified solicitor. Deputy District Judge Campbell, via his own motion, made an order to stay the proceedings and ordered that essentially a witness statement be provided by the claimant/respondent in relation to what was going on with the conducting of the litigation. He considered that Mr. Middleton was taking part in a reserved activity within the meaning of the Legal Services Act, the LSA. Now, pretty sharply after that, the respondent applied to lift the stay, and the qualified fee earner, who was supposedly supervising Mr. Middleton, filed a witness statement, which essentially stated that all the work that Mr. Middleton had been done so under the supervision of the qualified solicitor. Now, the application came before His Honour Judge Speechlys, who held that Mr. Middleton was authorised to conduct litigation under the supervision of the qualified solicitor. He subsequently ordered Mrs. Mazur to pay the cost of the application, which totalled over £10,000, and were done so on the standard basis, I should add. Mrs. Mazur appealed against this order, and there were two core points as identified by Mr. Justice Sheldon himself in the appeal. The first of which is, did His Honour Judge Speechlys err in deciding that Mr. Middleton was authorised to conduct litigation under the supervision of a qualified solicitor? And the second question is, did His Honour Judge Speechlys err in ordering costs on the assessed basis rather than fixed under CPR 45? It's important for me to add in relation to that we're only going to be discussing question one today. Probably it's fair to me to say that most, if not everyone here today, is probably more interested in the implications of the first of these two core points. And indeed, the vast majority of the judgment relates to the first of these 2 points. So we're not going to be discussing the basis on which the original costs order was made. So before I jump into the reasoning of the decision and the overall decision that the judge came to, I think it's really important just to go through some of the key provisions in the Legal Services Act. And the reason for this is because for those who have seen the judgment already, you'll know that it's essentially entirely based on an interpretation of the Legal Services Act, and it forms the absolute centre of the decision. So I'm just going to go through on about 3 or 4 slides the key provisions, and then that will put the decision of Mr. Justice Sheldon in context. So beginning with section 12, a reserved legal activity includes the conduct of litigation. Conduct of litigation is defined in the Act at Schedule 4, Paragraph 2, and it includes the issuing of proceedings, the commencement, prosecution, and defence of such proceedings, and the performance of any ancillary functions in relation to such proceedings. And the meaning of this will be discussed in a bit more detail by Kevin towards the end of the talk. But that's the core starting point. Now, Section 18 is particularly important because for the purposes of the Act, an authorised person in relation to an activity, or importantly, this reserved legal activity, the conducting of litigation, means a person who is authorised to carry out on the relevant activity by a relevant approved regulator in relation to the relevant activity. Now, Mr. Justice Sheldon singled out the SRA in relation to this, such that it is necessary, therefore, for a person to be authorised to carry on the relevant activity by the SRA. Paragraphs or sections 15 to 16 of the Act are quite important, but they're particularly long sections. Fortunately, Mr. Justice Sheldon did a quite helpful summaries of each of the sections in his judgment. So what I've simply done is taken his summary, put it in these slides, because quite frankly, it's probably the most succinct way to describe their importance. Section 15.2 of the Legal Services Act makes it clear that it's an employee who carries on the activity, i.e. the reserved legal activity, as an employee, is to be treated as a person carrying on the reserved legal activity, whether or not that employer is entitled to carry on that activity. Section 15.3 deals with the circumstances in which the employer will be treated as carrying on the legal activity by virtue of the employee carrying it on in their capacity as an employee of the employer. Now, I appreciate this is probably a bit of a confusingly worded section. And indeed, many of the sections of the LSA, in my opinion, are quite confusingly worded. But it will make sense in just a moment about how section 15 and 16 interacts. And before I touch upon section 16, although it's not on the slide, section 14 essentially provides that it's a criminal offence to be conducting a reserved legal activity if you're not an authorised person to do so. With that in mind, section 16 provides that where an employee conducts this offence, i.e. carrying out a reserved legal activity, the employer will also be committing an offence, even if the employer is entitled to carry on the relevant legal activity. And that's quite an important point to bear in mind, particularly for managers and directors. Now, the final slide in relation to the provisions of the LSA, we have section 13.2. And this essentially provides the only two ways in which a reserved legal activity, including conducting litigation, can be carried out. And they are: one, if they're an authorised person under section 18 in relation to that activity. And just by way of reminder, I can skip back quickly to section 18 to place that in context. There we go. Section 18, if you're an authorised person under this definition, i.e., you're authorised by an approved regulator, that's one way. Or two, if the person is an exempt person, and this is defined in section 19. Section 21 is an interesting provision, and that is something that the respondents in Mazur relied on quite heavily. Essentially, section 21, paragraph 3 states that in this section, a regulated person in relation to a body means a class of persons which consists of or includes persons who are authorised, essentially, to carry on an activity, which is a reserved legal activity, and importantly, persons who are not so authorised, but are employees of a person who is authorised. And in relation to an authorised person other than an individual, references in relation to an authorised person can include managers of that unauthorised person. The importance of this is that the respondents in Mazur argued that this provision, i.e. section 21 paragraph 3, authorised Mr. Middleton, who was an employee of an authorised person, of his manager, to carry out a reserved legal activity under the authorised entity's supervision. Well, Mr. Justice Sheldon did not agree. He concluded at paragraph 48 that Mr. Middleton was not entitled to conduct litigation under the supervision of the qualified solicitor, and His Honour Judge Speechlys had erred in law by finding otherwise. It's also worth noting, it's not in the slides here, but both the Law Society and the SRA were asked to provide comments, essentially, to Mr. Justice Sheldon during this appeal. And the conclusions they came to were also contrary to the conclusion that you see there in paragraph 48. So Mr. Justice Sheldon essentially went against His Honour Judge Speechlys and the SRA and the Law Society, or the conclusions that they had drawn in terms of how they interpreted the LSA. He also stated that it's clear from sections 15 and 16 that the Legal Services Act separates out the entitlement of the employees to carry out reserved legal activities from that of their employer. And if we remember what section 16, for instance, said, and just going back, that essentially the employer will also be liable for a criminal offence even if they have themselves authorisation to conduct litigation, if an employee of theirs is conducting litigation without that authorisation. But the importance of this is that, of course, section 16 would make no sense if the employee was able to carry out reserved legal activity simply because they were an employee of this authorised body. So essentially, it would have been nonsensical in Mr. Justice Sheldon's judgment to have Section 16 and yet employees to be permitted to carry out reserved legal activities simply because they were employed by the authorised body. And if you recall what the respondents argued in respect of Section 21, that extended the definition of an authorised person to those who are employed under the umbrella of an authorised entity, Mr. Justice Sheldon considered that Section 21 does not extend the definition of who is authorised to conduct reserved legal activities. And all Section 21 is doing is saying that an employees of an authorised person can be regulated. That's all that Section 21 is doing in respect of the question posed before the court in that case. And he considered that such an interpretation clearly fits with the other provisions in the LSA. For instance, he said those other provisions make a clear distinction between persons who are entitled to carry out reserved legal activities and those who are not. And with that in mind, Section 21 clearly does not extend the ambit of who is an authorised person. Additionally, something that Mr. Justice Sheldon relied on is that, by way of analogy perhaps, in Schedule 3 of the Act, paragraph 7, subparagraph 7a, an exemption for the purposes of exercising a right of audience for people who assist in the conduct of litigation was contemplated. That was specifically in the context of exercising a right of audience, not conducting litigation. But there is nothing in the Legal Services Act which contemplates a person who conducts litigation under the supervision of an authorised solicitor. So there is no analogy, if you like, that there is no equivalent provision that between what we see in paragraph 17a there of Schedule 3. Mr. Justice Sheldon made clear that there is a distinction between conducting litigation under supervision, which would not be permitted, and merely assisting or supporting an authorised person in the conduct of litigation. But it's important to note that that question in itself, or those two categories that Mr. Justice Sheldon identified, not only overlap, but their existence is very blurred. And in fact, there are many different scenarios, many different situations in which one may or may not be conducting litigation. But without straying too much into the implications, I'm going to hand back over to Kevin now, who's going to be discussing the implications of this decision and what it essentially means for the profession in a bit more detail.
Thank you, Fraser, for that exposition of the judgment, which is extremely detailed and helpful. So, one of the questions that we were asked was whether or not we think the decision will be overturned in the fullness of time. And the short answer to that is we don't know. Of course, we don't know. But I suppose the question is, do we think that it might be? You've heard Fraser talk through the conclusions. And I have to say, when I read the summary of the decision on the first post I came across on LinkedIn, it struck me as a bizarre decision. But when you go through the steps that Mr. Justice Sheldon went through in order to reach the conclusion that he did, there is at least a logic there which justifies his position. What's probably less helpful than me speculating with my own personal view as to whether or not the decision might be overturned is to look, given that this is a High Court decision which is currently binding upon us, at what the impact might be in the short term and perhaps in the longer term if the decision isn't overturned. And one of the things that Fraser's understandably focused his analysis on so far is the definition of reserved legal activity, and particularly the definition of the conduct of litigation, because it's that Mr. Justice Sheldon held that Mr. Middleton in Mazur wasn't authorised to undertake. And I start by looking at that definition and what the definition of conduct of litigation means, because I suspect we all have an initial view if somebody said, what does conduct of litigation mean to you? But I want to spend a little bit of time analysing what the technical term means in a legal sense and what that might mean for your individual practices. So I start with the explanatory note 65 to the Legal Services Act 2007, which is available on the legislation and .co.uk website. And that provides that all activities that were regulated under the previously enacted legislation remain enacted under the current. So this wasn't a piece of legislation that was intended to fundamentally change the pre-2007 position. It was intended expressly in the explanatory notes to maintain the 1990 Courts and Legal Services Act provision, which is the relevant act which preceded the Legal Services Act 2007. Cordery on the Cordery on Legal Services expressly says, and this was cited to the court in Mazur, that the starting point is that the drafting of the Legal Services Act 2007 didn't purport to create a new definition of reserved legal activities. Instead, it simply passported the definitions from previous legislation into the current legislation. That's not strictly true because there is a third limb to the test of what amounts to conduct of litigation, which I'll look at in a few moments. But in broad terms, that was the stated intention. What does that mean? Well, starting point is that it means that pre-2007 authorities are still of relevance and assistance because the law in that respect wasn't intended to change to any significant extent. But it does also beg the question, why in the 2007 Act is there a special carved out exception for people supervised by an authorised person in relation to exercising rights of audience, but no carved out exception when it comes to the conduct of litigation? And again, I read a very short paragraph from Cordery on legal services, which says that it may be that those drafting the 2007 Act did not consider that such an exemption was necessary because the conduct of litigation under supervision was always permitted, and the Legal Services Act 2007 did not purport to change the pre-existing law. And if that's right, excuse me, then it seems to me that Mr. Justice Sheldon has strayed from that overarching principle in reaching the decision that he did. But let's go back and have a look at what the conduct of litigation means or has meant in the context or in different contexts, going back to 2006 and the case of Agassi against Robinson, Agassi being a famous tennis player in his action against the Inspector of Taxes. So in that case, the court was considering sections 28 and 119 of the Courts and Legal Services Act. Section 28 is the provision that provided the restriction on who could conduct litigation, and 119 provided the definition of the conduct of litigation. And the two limbs to the test in the 1990 Act were A, to issue proceedings before any court, and B, to perform ancillary functions in relation to proceedings such as entering appearances to actions. Now, in considering the what that meant in practice, the Court of Appeal in Agassi said that only a litigant in person or an authorised litigator may issue proceedings. But what is the scope of the right to perform ancillary functions? Concluded that the background material to the 1990 Act didn't shed any light, so they had to bridge the gap. And in paragraphs 55 and 56, this is the conclusion that the court reached. First of all, they said that the two-limb description or definition of what it was to conduct litigation was not intended to be overly broad, that it was designed specifically with the first limb being to issue and conduct proceedings before the court, and that would have been all-embracing. The second limb of the definition that was adopted would have been unnecessary. And I've highlighted the paragraph there, the second part of that paragraph. Instead, the court concluded, Parliament decided to limit the first limb of the definition to the initial formal step in proceedings, their issue, and then added a second limb, which if its meaning is ambiguous or otherwise unclear, the court says must be construed narrowly. And in paragraph 56, I don't propose to read this out. I'm sure many of you will go away and read the judgment after this afternoon's talk. But there are three important things. The first is the court concluded that those words that were chosen must have meant that there are ancillary functions, or rather that the ancillary functions intended to be captured by the Act would be formal steps required in the conduct of litigation. So pausing there, the example that's given is the issue of proceedings. One might think that filing a defence, perhaps filing an acknowledgement of service, those sorts of formal steps required to conduct litigation would be caught by the ancillary functions, beyond simply the issue of proceedings. The court went on to say how unfortunate it was that the authors or the drafters of the legislation had left this important definition of what it is to conduct litigation so unclear. But they concluded, as authorities and courts had before them, that because there were penal implications to falling foul of the relevant section of the Act, that it was important that those words should be construed narrowly. In other words, it shouldn't be that a broad definition is given to those words which would capture a greater number of people falling foul of the authority. And interestingly, you'll see in the middle section there, they said, suffice it to say, we do not see how the giving of legal advice in connection with court proceedings can come within the definition of work which is ancillary to the conduct of litigation. Whilst that might be, on first glance, a surprising conclusion, excuse me, they went on to address other elements of work which are undoubtedly necessary functions of the conduct of litigation, but concluded that they were not ancillary to, in the sense that they fell within the definition of what it formally means to conduct litigation. And they were the correspondence with the opposing party. While they accepted that in a general sense was an integral part of the conduct of litigation, that didn't make it an ancillary function for the purposes of Section 28. So the analysis of the wording in the second limb, which is still the second limb in the 2007 Act, was extremely narrow and limited to those key formal steps required to conduct litigation, not to cover things like the giving of advice and the entering into correspondence with the opposing party. So that's where we started in 2006. In 2013, there was an unreported decision in Manchester called MSJ Associates against Brett Halliday. It was a High Court decision, and it's cited in the next High Court decision that we're going to have a look at. But I mention it briefly. I haven't seen a copy of the judgment, only what's said about it in the next authority. But I mention it briefly simply to draw the point that in that case, it was held that the service of documents was administrative support, not a reserved legal activity. And we'll come back to that concept of how or where in the spectrum service of documents falls when we look at another Court of Appeal case in a few moments. So the next authority, and this is a fairly brisk canter through the authorities that deal with this question of the definition of conduct of litigation. The next one is Heron Brothers in the TCC, where it was held that there was no reason to construe the definition of conduct of litigation as extending to any activities that take place prior to the issue of proceedings and which do not involve any contact with the court. And the example given in that case was advising on the merits of starting proceedings or drafting particulars of claim. So we can see already that there are, to some extent, a bit of dancing on the head of a pin required here, but there is a distinction, so say the authorities, between the issuing of a claim form, which is the formal act of starting or commencing court proceedings, and the drafting of particulars of claim, which might enable a party to issue a claim form and commence their legal claim. Anybody on this webinar who is involved in work that rarely leaves the pre-action protocol, so I'm thinking about low-value road traffic accident portal claims, might find this conclusion in Heron Brothers particularly interesting, because it seems to me that if that's right, any of the work involved up to and before, so not going beyond the portal, is caught by this and might be properly construed as not conducting litigation. I think the turning point is likely to be if you have to go into stage 3 and issue a Part 8 claim form, then the issuing of the Part 8 claim form is likely to fall the other side of the fence and amount to the conduct of litigation. But that's perhaps an authority that those of you involved in that work might be particularly interested in going to read. The Court of Appeal case that came in 2018 is Ndole Assets, and this is the one I signposted a few moments ago with regards to the physical act of service. In that case, Lord Justice Davis said that he considered that service of the claim form is an aspect of the prosecution of proceedings. So not just the issuing of the claim form, but the service of the claim form, and that was an ancillary function in relation to such proceedings. But the Court of Appeal went further at paragraph 59 of the judgment. Again, this is an important authority which it seems to me would reward the reader tenfold, rather than just listening to me pull out some strands. But at paragraph 59, the Court of Appeal, considering the decision of its predecessor in Agassi, said it must have been intended that ancillary functions would be formal steps required in the conduct of litigation. There are rules of court relating to the formal step of issuing a claim form. A legal action can't be progressed, can't be prosecuted unless and until the claim form is properly served. And therefore the conclusion at the bottom of that paragraph that service of a claim form falls within the ambit of the statutory language naturally read. But there's a problem that falls from this, or that stems from this, which is that when is a claim form served and by whom? So take the example of the solicitor who drafts the claim form, drafts the particulars of claim, and sends them to court by printing them off, packing them in an envelope themselves, and sending them off to court for issue. There could be no doubt that the qualified solicitor who's authorised to conduct litigation has undertaken that step. But what if they drafted the documents and then sent them to some secretarial support staff, and it was the support staff who's unqualified who pressed print, stuffed them into an envelope and and sent them off to the court, or e-filed them through CE-file or something of that ilk? Could it properly be said that the qualified person was not the person who'd issued the proceedings because they hadn't taken the formal step of clicking on CE-file to lodge the document or fulfilling the envelope? Quite clearly, that wouldn't be the case. But you can start to see, I'm using two perhaps slightly extreme examples, you can start to see where the difficulty might arise if we employ too robust or strict an interpretation to the physical act or the legal act of issuing a claim form and court proceedings. And the Court of Appeal acknowledged that problem in Ndole Assets, and they dealt with it in this way. They were concerned with the idea that a postman might serve the proceedings by posting them through the defendant's letterbox. And could it be said that it was the postman that served the claim rather than the lawyer who stuffed the envelope, or the lawyer who instructed some support staff to stuff the envelope? And this is what the Court of Appeal said in Ndole. This is where substance has to prevail over form. I acknowledge that it's not always appropriate to talk in terms of degrees of agency, and words that will, I'm sure, strike fear into the heart of any litigator. It all depends. And drawing the distinguishing feature between those who merely perform an administrative or mechanical function in connection with the service of documents, and those who undertake, or, and I would add my own emphasis here, have assumed legal responsibility with regard to service as prescribed by the rules. So just pause there and think about how that might be interpreted in a modern litigation department. It seems to me if the drafting of particulars of claim is not itself an act which gives rise to or falls within the definition of the conduct of litigation, but the decision-making behind it, it's not the administrative or mechanical function of serving, but it's the decision who takes legal responsibility for service, who decides to send it by first-class post or to send it by recorded delivery or some other mechanism. If that's the determining factor, then one can quite see that a partner or a solicitor, anybody who's authorised to conduct litigation, who delegates the physical task of sending the post or sending something by email or filing to paralegal or some other non-authorised fee earner, then under the principle in Ndole, that is unlikely, it seems to me, to fall foul of conduct of litigation rules and the definition of that, such that it would have any negative impact on those persons involved. So moving on from Ndole, which was forgive me, 2018, the same year, there's a case of Ellis against Ministry of Justice. Now, in this case, it went to the Court of Appeal, I think, in 2019 or 2020. And it's worth having a look at that decision as well, because that's an example of, I think it was Mr. Ellis was found as a person who was not authorised to conduct litigation, to have conducted litigation, having undertaken all of the work that you might expect an instructed solicitor to undertake. I'm going to look at another case at the end of this talk, which concluded very similar, in very similar circumstances, that the fee earner involved in that litigation had fallen foul of the authorities and the statute. But the reason I mention Ellis now is because the first instance appeal before Mrs. Justice May, forgive me, she rejected a submission that looked at the motivation behind the relevant act as being significant. So it was said in that case that the person who was the driving force behind the issue of proceedings was authorised. The person acting on those instructions was not authorised. Now, in fact, having rejected the idea that motivation was relevant, she concluded that actually a far more straightforward analysis was that the step itself fell outside of the reserved legal activity. But again, this is an authority which rewards the reader in having a look at how the court considered that question of whether or not somebody was effectively the decision maker, which it seems to me to lie consistently with the Court of Appeal's approach in Ndole, looking at who assumed legal responsibility for the step in question. Last few cases now, JK and MK. This is a case in the family division. It's a very short judgment, and it's worth having a look at simply to see the factual background to it, which I won't set out in any detail here, but suffice it to say there was a company where two people who wanted to be divorced were agreed as to how their assets should be split, but needed some assistance in working through the legal process. The firm, which was called, I forget now, forgive me, Amicable would draft all the relevant papers, all the relevant forms, the consent orders, the documents which lay behind and supported those positions, and then had the parties agree them. And interestingly, Amicable then filed the documents, of course, and used their court fees account to pay the relevant court fees. And in this case, Mr. Justice Moyston said that the giving of legal advice per se by someone who is not a qualified lawyer is not prohibited. Well, that's consistent with the authority we looked at the beginning of my section this afternoon. But he then considered, what if the advice extended to the drafting of a claim form, such as a petition or an application, in that case for a decree nisi, or the witness statement in support of an application? And his conclusion, and it seems to me, reading the judgment, that this is an obiter conclusion, so it does warrant some careful hesitation before relying upon it too heavily. But his conclusion was that it would be surprising if it were forbidden for an unqualified, unauthorised fee earner to assist with the drafting of an application or a witness statement in support, or even the drafting of a claim form. And at paragraph 29, he concluded that all of that work which had been done by Amicable didn't transgress paragraph 4 of Schedule 2 of the Legal Services Act. Interestingly, the straw that broke the camel's back in Mr. Justice Moyston's mind was the fact that the covering letter sending the documents to court was on Amicable's notepaper. You may have your own views about how important or relevant that particular aspect of this litigation was, but beyond that, he didn't see anything difficult, even with the fee being taken out of Amicable's fees account. Last couple of authorities, two more. I say authority, this one isn't binding in any way, shape or form. This is a decision of the Visitors of the Inns of Court, so a decision brought by the Bar Standards Board, a prosecution brought by the Bar Standards Board against counsel called O'Connor. And it was held in that case that the signing of a statement of truth on behalf of a client didn't amount to the conduct of litigation. That was a direct access barrister who had assisted somebody in the filing of documents and had signed a statement of truth on behalf of a client. As I say, not binding. It seems to me, goes a little bit further than most of the other authorities. And I would urge anybody to exercise some caution about the conclusions in that. But I've put the link on it, a judgment available on the Bar Standards Board website. The link's on the slides. The last case is Baxter and Dobble. This was a CILEX fellow, but one who wasn't authorised to conduct litigation. And Mr. Justice Kavanagh, in exercising his discretion in considering whether or not, or I suppose exercising a finding of fact, in deciding whether or not the actions of the Mrs. Dobble in this case fell within or out with the definition of conduct of litigation, said that there were 4 key points. First of all, the statutory language itself. Second of all, that point that was considered right at the beginning in Agassi, that this is penal legislation and therefore the margins ought to be narrow. Lastly, that substance must prevail over form, as we've seen in the Indole case, and penultimately. And then lastly, that the question is one of fact and degree in every case. And that's why I opened this with the health warning that I did, to say that we're not giving any legal advice today, but all of these circumstances will be unique to your individual practices, or largely unique. And they will be considered differently should a matter involving you ever come before the courts. Now, in Baxter, the court said effectively Mrs. Dobble did everything. She or her firm gave full service assistance, including drafting all the documents, giving instructions to counsel, making payments into court, corresponding with the other side, ensuring that all procedural steps have been complied with the CPR, and effectively took the step back, looked at the form, or the substance rather than the form, and said it would be right to say that somebody has conducted this litigation. And it would be wholly artificial to say that it was Mrs. Dobble's client who conducted the litigation simply because Mrs. Dobble or her firm were not on the record. She had done everything. And so taking a step back and looking at the matters in the round, it was Mrs. Dobble, who was unauthorised to conduct litigation, who had conducted this litigation. Drawing that back now, because we're quickly running out of time and we've slightly run over already, what does that mean in the context of the Mazur and Charles Russell Speechlys case? Well, I've seen a lot of discussion on LinkedIn and elsewhere about the ramifications of this decision, but it's important not to extend Mr. Justice Sheldon's conclusions beyond what those conclusions actually were. If you look at the authority, in paragraph 48, the question was asked, was Mr. Middleton entitled to conduct litigation under supervision of Mr. Ashall, who was authorised to conduct litigation? And Mr. Justice Sheldon answered that question, no. Then at paragraph 67, Mr. Justice Sheldon concluded that he did not need to decide for the purposes of that appeal whether Mr. Middleton was conducting litigation or under the supervision of Mr. Ashall, or whether he was merely assisting. And that seems to Fraser and I to be because by the time the case came before Mr. Justice Sheldon, Mr. Middleton had effectively been replaced and was having no further involvement in the litigation. Mr. Ashall had taken over conduct of litigation. So it's important to recognise that in this decision, he didn't decide that Mr. Middleton's work was assisting work, supporting Mr. Ashall in the conduct of litigation. He simply drew the conclusion that Mr. Middleton wasn't entitled to conduct the litigation under supervision. And so, in our view, it's important that this decision is not misinterpreted to draw a conclusion which the court explicitly refused to draw. What does that mean for the future? Well, I don't ever want to say your guess is as good as mine, but clearly what I hope has come across over the course of the last 45 minutes is that these are not straightforward issues, that they are issues that the courts have grappled with in a slightly different context for a considerable period of time. And all of this really flows from the fact that the definition of the reserved legal activity of conduct of litigation in the Act is not as well defined as it might have been. But in terms of practical steps going forward, what could we usefully suggest is something that you ought to engage in? Well, the first thing would be to review everybody involved in litigation, it seems to me, should review their office procedures after this piece of authoritative case law to establish the extent to which, as a whole, it might be said that unauthorised persons are conducting litigation, having regard to the authorities that I've drawn to your attention. I promise this isn't Fraser or I touting for work, but you'll see, I hope, how case-specific these decisions are. And it is crucial, it seems to me, that you take legal advice on your own specific circumstances. The nature of the questions that we received in advance of today have certainly demonstrated to me that this spans across a huge number of practice areas and a huge number of different setups between an individual supervisor looking after either a small number or a much larger number of individual non-qualified fee earners, right up to a mixed team, and what steps can and can't be taken by individual people within those teams. It would be sensible, it seems to us, to ensure that any formal steps, those that are discussed in Agassiz and the other authorities, are taken exclusively by authorised persons. So the issuing of a claim form, the signing of key court documents, defences, and perhaps, and I express some hesitation about this, but perhaps even things like directions questionnaires, listing questionnaires, consent orders, etc., that those formal steps are only taken exclusively by authorised persons, at least in the short term, until the dust has settled and we have a better idea as to what the implications are. The next thing I would say is that, in line with the decision of the Court of Appeal in Endole, consider who's taking legal responsibility for formal actions. So it may well be that certain tasks can be delegated to unqualified fee earners to undertake some preparatory work, first draft of particulars of claim, consider a medical report and provide me with a summarised note of the conclusions. But that the formal steps, the legal responsibility for those formal actions, making Part 36 offers, for example, that should all be within the remit of a qualified and authorised fee earner. In terms of steps already taken, that was one of the questions we were asked. If, for example, a claim form has been issued by an unqualified fee earner, not authorised to conduct litigation, what does that mean for the action? I'm afraid the jury's out on that, but I would draw your attention, if that is applicable to you, to CPR Rule 3.10, which gives the court an absolute discretion to effectively validate invalid steps which have already been taken. My personal view, not case specific and not being advice, is that I think it's extremely unlikely that if an unqualified fee earner conducting litigation, if that's the appropriate analysis, by issuing a claim form as part of a larger team which has qualified fee earners, I think it's extremely unlikely that a claim form or a claim would be struck out simply because it's been issued by somebody who is unqualified. But that could well be a conclusion of a judge who takes a different view to me. So be aware of CPR 3.10 should you need it. We were asked a lot of questions about cost draftsmen who are not cost lawyers and can't conduct litigation in that sphere. It seems to me that this applies precisely to cost draftsmen as it does any other unqualified fee earner. So in the course of costs proceedings, I would be thinking about things like serving an N252 notice of commencement as a formal step, serving perhaps points of dispute or points of reply, even perhaps requesting a detailed assessment hearing under N258, all seem to me to be formal legal steps engaging with the court, at least to some extent, which ought to be conducted by authorised fee earners. And the last point is perhaps a big one, but not one that we could legitimately explore today because of its potential size, which is whether or not, if steps have been taken by litigators who are not authorised to conduct litigation, will that affect the recovery of costs in those cases? It seems to me, and again, this is not advice, and it's likely to be addressed by the courts, the authoritative courts, in some future point. But it seems to me that there are one of two things that could happen. Either the court could say, well, this entire claim has been run by a paralegal. Nobody qualified has ever looked at it. It's been run from start to finish by a paralegal, and the entire costs are tainted by that breach of the statutory provisions. Or, I think just as likely, is that a court might look and say, well, the issuing of the claim form was an act which that particular fee earner could not legitimately and legally have undertaken, and therefore I'm not going to allow the costs of that unqualified fee earner issuing the claim form. But the other act, making or filling in the witness statement, drafting witness statements in support of applications, instructing medical experts, etc., which arguably do not fall within the definition of the conduct of proceedings, those acts are still, or the costs of those acts are still recoverable, even if certain elements of the work are not recoverable, because they were the conduct of litigation undertaken by somebody not authorized to undertake those tasks. So I'm afraid, and I apologize if that's less conclusive than you might have liked, but we don't have all of the answers. This is likely to drill on for quite some time, and forewarned is forearmed, but take legal advice on your own situations. And the one thing I can emphasize is that it's important to take, or almost certainly important to take, steps now to protect yourselves and your practices going forwards. So thank you very much for your time. I'm sorry that we've run over by about 10 minutes or so. As I say, please feel free to watch this back. I know that we've given you a huge amount of information over the course of the last 55 minutes or so. It should be available online tomorrow via our King's Chambers website. Thank you very much, everyone.
And just by way of final housekeeping, I noticed that 1,000 people joined today, and that is our capacity for Zoom. We can't, more than 1,000 people can't join this webinar, unfortunately, due to our Zoom account settings. So if you know anybody that tried to join and wasn't able to, please just let them know that this recording, as Kevin said, will be available, and so will the slides. So they should be able to access them there. Thanks, everyone.
Thanks, everyone. Bye now.